Hey guys, welcome to this video. My name is John Watts. I'm a consumer protection lawyer, and I want us to look at a very recent case from the 11th Circuit Court of Appeals. And you can see this is February the 12th, the 11th Circuit. So that's Alabama, Georgia, and Florida. And this involves the FDCPA, Fair Debt Collection Practices Act. And I want you to see it for two reasons. Number one, it illustrates this concept of strict liability. And then number two, it talks about the idea of a bona fide error defense. That's where a debt collector says, well, don't hold me liable because I have this bona fide error defense. And the court says you absolutely violated law and you absolutely do not have a bona fide error defense. It's a little bit unusual. Summary judgment was granted in favor of the consumer against the debt collector, and the 11th Circuit said, the trial judge, the district court judge did it absolutely right. So let's take a look at this. And this arises out of Florida. And so we have this Fern Kottler, I guess that's how you say it, Fern Kottler's complaint saying Gulf Coast Collection Bureau violated the FDCPA for sending a validation notice for a debt arising from an injury that was a work comp. So this was an on-the-job injury. And we'll see under Florida law, there's no right to collect from the injured employee when it is a work comp claim. And so the debt collector says, well, hey, consumer plaintiff, you suffered no concrete injury. And that's this thing under Spokio that we've talked about. And that's to just throw the case out. And then they say, we're not liable for sending you that letter, and we weren't trying to collect. And if we were liable and we were trying to collect, then we had bona fide error. And the court rejects every argument from the debt collector. So what's summary judgment? That's when there's no genuine dispute as to any material or important fact. And the movement, that's the plaintiff here, the consumer, is entitled to judgment as a matter of law. So first, the court always has to address this idea of standing or Spokio challenge. And the court says, well, look, you suffered a concrete injury and that gave you standing. So how do we know that? Well, standing has three elements. Number one, injury in fact. That's what all the battle's over. But number two is the defendant has the cause of the injury. Number three, you have to have the ability for the court to somehow redress it or make it right. And so, again, we're going to focus on this injury in fact, and the court says there are four aspects to that. Number one, legally protected interest has to be invaded. Number two, your injury has to be concrete. Number three, particularized. In other words, not just general that it affects everybody. And then number four, it has to be imminent. And so, well, what does the consumer say? Well, she said, I got telephone calls, I got a letter suggesting that I was liable for medical bills. And she said, I was clustered and jumbled. I was scared. I was afraid you're going to ruin my credit. And the court says, you satisfied everything. And you were entitled to avoid communication concerning collections of debt you do not owe. Now it says 1562. It's actually 1692E. That's just a typo in the court opinion. And so remember we talked about in the last video the strict liability idea that if they go sort of beyond the bounds of the law, boom, they're liable for it. It doesn't matter their intent. And so she did not owe this debt, and yet they said she did. All right, there's violation of the law. And she expended time addressing unwarranted collection calls, and those calls upset her. Now, they reference a lot this trickle or Tritchell, depending on how you pronounce it. It's a case involving Midland, and I think the quote, it's up here, Midland Credit. That's from 2020, and they threw out a case. So if you're interested, I'll go through that. It's a pretty long opinion, but just let me know in the comments if you'd like to see that. And so now they say, look, nobody questions the collector sent the consumer here a dunning letter, a collection letter. And now remember, Gulf Coast, the collector said, we didn't send you a collection letter. We just were giving you information. And the court says, well, you said, here's how to pay the outstanding debt. Okay, number one. Your account's been listed for collection. This is an attempt to collect a debt. So it's kind of weird when the collector says, by the way, this is an attempt to collect a debt. Then you sue them and they go, what are you talking about? We weren't trying to collect a debt. Well, it says right there, this is an attempt to collect a debt. And then it told her if she did not notify them within 30 days she disputed it, they would assume the debt's valid. And it also said you're responsible for and overdue in paying outstanding medical bills. So no question about this is an attempt to collect a debt. And then the court says, look, 1692E2A, that's what the court was trying to communicate up here where, I forget where it is. But anyway, right here, that's just a typo. It should say 1692E. And so it's correct down here. So you can't make any false representation of the character, amount, or legal status. Well, saying you owe the debt when you don't owe the debt, that certainly violates it. Subjects it to liability even when violations are not knowing or intentional. Well, so what's a false representation? If an unsophisticated or naive consumer would be deceived, then it's a false statement. And so we have the debt collector saying you have to pay your medical bills, but in Florida, an employee is not liable for payment for medical treatment or services, and a healthcare provider may not collect or receive a fee from the injured employee. In other words, you got to go to the employer to get this. And so the court says if we have somebody that is naive or least sophisticated consumer, they would be misled into thinking they were obligated. Well, why would they think that? Because they got a letter saying, you owe this debt. You're overdue. You must pay it. I mean, it's sort of weird when the debt collector said, well, we don't think anybody could have been confused by that. We think everybody would know that we were lying. No, that's not the standard. So Gulf Coast falsely represented the legal status of the debt for the plaintiff, the consumer's medical bills. So they're on the hook now. Because remember we talked about kind of like there's a box. You go outside that box, any direction, you violate the law. If I build my fence over an inch, a foot, 10 feet on your property line, I have violated your property rights. Same thing here. So now the debt collector said, but we didn't mean to. And so we should be shielded from this because of bona fide error. They say, no, not at all. So you've got to show that it was not intentional, it was a bona fide error, and it occurred despite the maintenance of procedures reasonably adapted to avoid such error. Different courts word it differently. That's how this court's wording it. And really the only disputes on that third element, which is maintenance of procedures reasonably adapted to avoid such error. And they say, well, to get the protection of that, look, you actually have to employ or implement procedures to avoid error, and then you have to ensure that those procedures were reasonably adapted to avoid the specific error. It's kind of a joke, but this is where debt collectors say, but we have in our policy manual, and we make every employee swear they will not violate the law. What does that mean? Okay, you got to get really, really specific to avoid this specific violation of the law. And they say Gulf Coast implemented procedures that were not reasonably tailored to identify the debt covered by work comp. So it's not just, well, we have a procedure, don't violate the law. That's not good enough. Well, we have a procedure not to violate the FDCPA. Not good. We have a procedure not to collect a debt that is not owed. It's not good enough. It's got to be so specific. You have to identify the debts that are covered by Florida worker comp law. That's how specific you have to be. And they didn't do that. Instead, they just relied on their clients. Okay? And they say, no, that's not good enough. Use no additional screening procedures to detect if a debt was subject to workers' compensation because you relegated its oversight task to its creditors. No, you just said, you know what, I'm going to make the creditors tell me whether or not this is work comp. And you lacked internal controls to reduce the incidence of improper debt collection. You're not entitled to avoid liability for bona fide error. So this is a fantastic opinion. It's, some opinions are 40 pages long. This is a short opinion, okay, not very long, but we have these three judges, Judges William Pryor, Chief Judge Newsom, and Judge Anderson, It's just short, it's to the point, it's clear, it's understandable. It's a fantastic opinion. And this is what we should be seeing from our courts when we're dealing with these types of violations of the law. So again, if you want to read this, here's the case number. I think I can put a link in to it. I'll find the link to the 11th Circuit so you can read this yourself. And again, great opinion. And I wanted you to see it for what constitutes an FDCPA violation and how it doesn't matter what their intent is, except on that bona fide error. But it's got to be so closely, specifically, narrowly tied to the violation. And I'll just tell you this, in all the years I've been suing debt collectors, the trials we've had against debt collectors, I've never seen them even come close to bona fide error. So as a practical matter, the FDCPA is almost always strict liability. You go against the law, you're on the hook for it. Doesn't matter what your intent is. So thanks for watching this, and let me know if there are any other opinions you want me to go through. And I'll try to do more of these where as new opinions or even older opinions that are important come out, I'll go through them. So thanks for watching, and I'll talk to you later. Bye-bye.